So we've got quite a few folks here on the line. Is that what you call it? A line? On the computer, I guess. So I would first like to start by introducing the staff that we have here today. We've got Bryn Hudson, who's our legislative coordinator. We've got Laura Hart, who's our rules coordinator. We've got who else from our staff? Will Davidson, who does our contested cases. He's our protest coordinator. Lots of coordinators on today. And then we also have Jesse Ratcliffe, who is with the Department of Justice and is our general counsel, and is here on behalf of the agency WRD today. And then myself, my name is Raquel Rancier, and I am one of the deputy directors at the Water Resources Department. So that's who we have from the agency today. I'd like to move through briefly just a walkthrough of the folks that are attending today so we can get a sense of who's here either on behalf of a RAC member or who's here attending in a public capacity or otherwise. So I would like to go through the list just in the order that I'm seeing it. So it's going to be first name by first name, alphabetical order. And actually, I am remiss before I go. We also have Donna Braun here, who's with the Office of Administrative Hearings. And so one of our key partners, at least in our Division 2 update, is a result of that legislation. So Donna, thank you so much for attending today and sitting in as well. So that's who's here, I believe. And I see now we have ODFW has also joined, Danette Fossera. So with that, I'd like to go through the list of folks that are the non-agency land folks. And so I'm going to walk through this list here. Brian, can you start us off with a brief introduction?
You're talking to me? Sorry, I don't know if there's another Brian on.
You are
Okay.
the Brian. Yes.
Okay. Yeah. Hi, everybody. Brian Posowitz with Water Watch.
Okay. And then Daryl Dunn. Daryl, can you hear us? And would you like to introduce yourself? Okay, we're going to move to Glenn Barrett.
Yeah, I'm here, Glenn Barrett with Water for Life, and I'm also on the RAC committee.
Thank you, Glenn. And James?
Good morning, everyone. James Fraser with Trout Unlimited. We are on the RAC. Thanks.
Okay, Jesse.
Good morning, everyone. Jesse Talbot with Central Oregon Irrigation District.
Okay. And also a RAC member, JR. Or wait, did I already get to JR? Jesse, things are moving around on me. JR,
Northeast Oregon Water Association.
thank you, JR. Karen.
Always takes me a while to find those little guys. Karen Lowatsky, Oregon Environmental Council Water Program Director and Rural Partnership Lead.
And Karen, you're a RAC member too, correct?
Yes.
Okay. Ken.
Ken Yates, Oregon Water Resources Congress, and I'm substituting for April Snell, our executive director, who is on the RAC.
And Marika?
Hey there, Marika Sitz. I'm an attorney at Jordan Ramus, and I am subbing in for Jeff Stone on behalf of the Oregon Nurseries Association, and we're a RAC member.
And Mark?
Mark Landauer with the Special Districts Association and Oregon Association of Water Utilities. I believe that I'm a RAC member. Thank you.
Okay. Michaela.
Excuse the Halloween makeup. But my name is Michaela Watson, and I'm here supporting Jesse with CYD.
Great. Okay. And let's see, Richard.
Morning, Richard Kosas and Water for Life.
Okay, thank you, Richard. And then let's see, Daryl, just going back to you since I didn't hear you earlier. Okay. I'm still not hearing you, Daryl, if you're speaking. Did I miss anyone from an introduction standpoint? Okay. Michaela, your Halloween makeup is great. I actually have my Halloween costume. For those of you that don't know, our longtime Northwest Region Manager, Mike McCord, is retiring. And so I have dressed up as Mike today. He's always wearing a beaver hat, but I figured having a hat in a meeting was a little too much considering I'm facilitating. So all your Halloween costumes are certainly welcome though in this meeting. So don't be shy in terms of turning on video for us here. Okay, so with that, we are going to get started and get into some of the follow-up that at our last RAC meeting that we talked about Division 2 on. There was some key areas that folks wanted to do a bit more of a deeper dive on. And so I have noted those and specifically the ones that I've noted are this is all under 690-002-0000, which is kind of the applicability and purpose section first. And then the other area that I had noted folks wanted to talk a little bit more about was 0075. And then and that one is for ones that are not affected by the new legislation. And then we also had 0095, which was discovery. I think that's probably where we will spend a significant portion of this meeting, as well as the default hearing schedule under 205. And then there was one that we didn't get to in the RAC meeting, but it's a bigger section. And so I wanted to, if we have time, make sure we touch on it, which is 225 requests for party status. So those were the areas that I think I had identified as I think folks were wanting to do a bit of a deeper dive. I guess I'd ask for the group, are there any of the rules that I didn't list off that you were hoping for us to talk more about in this deeper dive, keeping in mind that if it's higher level stuff, we will be coming back to the bigger RAC meeting at a future meeting. So any other ones that were that you all wanted to do a bit of a deeper dive on? Or did I hit the mark? Let's see. I'm not seeing any hands at the moment. And yes, thank you, Laura, for putting that in the chat. I'd appreciate, it's always a lot managing a meeting, so I appreciate if we refrain from using the chat and unless it's needed to communicate to staff that, hey, something's gone wrong, right? Or, hey, you keep missing my hand, things like that. So, Brian.
Yeah, and so I as folks are aware, I have not been participating in the RAC. I'm sort of the proxy here on the contested case issues, just because I've done some contested cases. And I think so. Yeah, I think you're right in terms of the big issues for discussion would be the default schedule and the discovery. At least in my mind, there are several sort of other kind of more nitpicky things that I assume we can just raise in written comments or that kind of thing. And I don't want to bog the meeting down with that, but.
Yes, and we've received some of those comments already. So you all in your materials, thank you. This is good opportunity, Brian, for me to raise what we've received to date. So in your materials, you have a V2, version 2 of the Division 2 rules, where we had made some edits based on the first, on the RAC discussion from the last go round where we could, like you all were juggling a lot of tasks, so we didn't get through all of them. But the ones that we did address, we have shown that in that, what we're calling our rule tracker. And those ones are all, I believe, highlighted in green. Then we've got ones that you probably saw I highlighted in like an orangish color that was like, we're waiting for the discussion today. So those are pretty much all affecting those key areas that I had just listed off today for the most part. And then there's some other ones that we think are probably that don't require a full discussion, and they're towards, I think, the bottom, they're under review, and those are ones that I looked at and I was like, I don't think this is I think this just needs more time with us internally to discuss, and we just didn't have time before we got that out for you all. But I don't anticipate that we necessarily need a discussion today. There very well may be other items that you all have flagged and that we haven't received yet. And so you are welcome to send those in to us, and please do that so we can take a look at them and assess whether changes are needed to the rules on that front. So with that, I'm going to turn our attention then to the rule divisions, and I guess I'm now realizing I said I will be running this, so give me a second here to.
I dropped the documents in the chat
Ooh.
for everybody. I don't know if that's helpful, but
give me a second to get through the morass of documents. There we are. And it's been a while, so here it is. Okay. So I am now sharing. Theoretically, you all can see that. And this is the Division 2 text. And so one of the items that I saw that was I wonder if you all can see that. Is it helpful for me to share screen, or is it a distraction for you all? Is it too small? I just want to make sure it's helpful and not just a distraction. There we go. I think that gives you the full set. Yes. Okay. So one of the questions that I saw arising in various components of the comments, both on Division 2, but as well as in other rule divisions, was questions around the relationship. And so Jesse, you're on deck here, just so you know. I'm about to call on you. The relationship between the Administrative Procedures Act and House Bill 3544 and these Division 2 rules. And when is it that the agency needs to be relying on those rules, the 137 model rules, versus the protest and contested case? And why can't we standardize all of them versus having some where these new rules apply, whereas others where they don't apply? So Jesse, I know we've talked a little bit about this, and I think it was something that we wanted to raise here, at least to discuss a little bit of our thinking there. So can I put you on the spot on that one?
Sure. So the baseline for administrative hearings in the state that are heard by the Office of Administrative Hearings is you're starting with the APA, Chapter 183, and that's what applies. And then for the OAH hearings, and Chapter 183 specifies which agencies are required to use the OAH, and OWRD is one. Then the Department of Justice has adopted model rules of procedure that govern OAH hearings. And so unless there is something more specific in an agency's own statutes, that's the framework that you're working with. And there are a couple of places in the model rules where agencies are allowed to adopt their own more specific rules without any additional authority. Discovery is one of those. And there are a couple of other examples, but for today's purposes, that's one of the key ones. So that's the basic framework. And then some agencies have more specific statutes that will supplement, in some cases override, portions of the APA or the model rules. And so that's what we're working with here, is that with the passage of 3544, we have, in some instances, the legislature superseding very specific parts of that basic framework, but only as to the processes that are covered by 3544. And that's where this gets legitimately confusing, because not every single one of OWRD's processes that could lead to a contested case is covered by 3544. So what the agency is trying to do here in Division 2 is try to parse all that out and explain what sets of rules are going to be applying to what processes. Most of the department's application processes are covered by House Bill 3544, but there were a handful that the legislature decided were just too much to take on, at least in the past session. Those are primarily the hydro processes, because in at least a couple of cases, there are some very specific things that go on in hydro processes that are different than most applications. There's an intersection with the Federal Energy Regulatory Commission in some cases that makes it different. In any event, that is kind of the outlier for application processes. So in drafting the rules, the agency's tried its best here to standardize where it is possible to do so. But because of these different layers and because of what House Bill 3544 does and does not cover, there's only so far the agency can go to do that. If folks have ideas for, increasing uniformity that fit within the kind of background legal framework that we're working within, that's great. We may have missed things, but that is the reason why there remain some differences.
Okay, so I'll pause there. Jesse, one of the other areas where we've received some comments is just, and we will be looking at it more closely, but I don't know if you want to address this at all, is just where requests for party status come in light of some of the areas that we removed because we didn't have authority for fees related to requests for standing. This is mostly coming through the hydro realm. And so I know there's been some questions around making sure that it's clear that throughout the rules that it's not just protests that are governed by Division 2, but also the request for party status and, if necessary, the model rules. So that's something we'll be taking a closer look at. I don't know if there's anything else you wanted to add on that front.
Yeah, so is one example where 3544 provided the department some additional authority to do something slightly different as to the processes that are governed by 3544. And so there is a party status rule in here that is intended to implement 3544. The substantive standard for obtaining party status isn't changed. It's more the surrounding processes that we're working with. And so that's why there's a specific party status rule there.
And for folks that don't know, there already is. So if House Bill 3544 doesn't govern, 137003, which is the model rules, would, right? And there are provisions in there as part of the contested case process that address those requests for party status, essentially. So, okay, so I'm just going to pause and see if there's any other questions or comments on, a lot of these were coming up, I think, under OOO. And so I just wanted to see if there was any other questions on this kind of overarching puzzle that we're putting together here, or comments. Brian.
Yeah, just if this is off topic, just that's fine. But so I appreciate what you're saying there as far as 3544 didn't apply to all the department processes. And that hydro is a complicated area. In the hydro realm, there is this process, as you know, for converting hydro rights to in-stream rights under certain circumstances. And the statute doesn't provide any process on that really, but there are rules that do, and they set up a process of a proposed order and a chance to protest and so on. And I don't know where you are landing at this point in terms of extending the standardization that's happening in this process to that process. I think that's been something Water Watch has raised, and to me, you could do it within the statutory constraints, and I don't know where that is at this point.
Brian, my recollection is House Bill 3544 does not apply to ORS Chapter 543. So, which is the hydro statute. So I'll just flag that in terms of there's limits there, because while I acknowledge that House Bill 3544 does say that, and the standardization can apply, to any procedure that we've applied it to in rule, right? If it's not called out by the statute. I think on the hydro one, the lead into that provision that says that does not include ORS Chapter 543. So there is still a limit there. I think there is a little bit of standardization that we are looking to do. And for example, default, orders on default and things like that, where we've standardized it across our processes. So we've started to go there. But we haven't been able to do it on everything, right? Because that statute that did pass does have limitations there. I don't know, Jesse, do you have anything else to add on that front?
No, that covers it, I think.
Okay. Brian, does that make sense?
Yeah, I'll have to go back and look at that. I didn't understand the bill to preclude extending some of this standardization to that particular process, but I'll go back and look at it again. And I think, in terms of requests for party status and so on and so forth, but I'll go back and look at that. But I think, we're in favor of a standard PFO and protest process for whatever wherever that can be done. And my view is it could be done in that area, but maybe I'm wrong, and we'll go back and look at the.
Yeah. Feel free to go back and look and let us know if you're seeing something that we're not at the moment. I do think that could be a future avenue, honestly, is hydro, and maybe looking at the hydro statutes, because they are a bit more complicated, right? And that moving this standardization, I think it would make sense. So you need to do the statutory adjustments, then apply the rules to it so you could have a comprehensive standardization. So, and no, I'm not promising that we will do that, by the way. I'm just musing here that there probably could be some something there that would allow us to make it, the more standardization we can do, I think the better, because it reduces the likelihood of mistakes, right? And it also it leads to some efficiencies internally. And it also helps you all, to your point, know what to expect, right? You don't have to go, just like you all, we have to go fishing for, okay, what process is this? And what is what's the process? Because every process is unique and we're trying to move away from that. So I think our long-term goal is there. I just don't think we were able to get there this go around with this current legislation as well as with the current rulemaking, but we're moving in the right direction, I think. Okay, so with that, I'm going to move us to, I'm not seeing any other hands, by the way. So if I'm missing, am I missing hands, by the way? I assume it'll push you all to the top of the list. So, all right. So I'm going to go ahead and move us down to the next one, which was 0075 that we had noted. I think folks, we'd asked a question to you all. You all had raised an issue, and then we asked a question back to the group. So, which is this one. This is 75. And Donna, since you are here, you're welcome to also chime in, by the way. But during the RAC meeting, there was a discussion of how this, and as identified by the ALJ, seemed to lead to confusion. And so there was a suggestion that to cut the qualifier and as identified by the administrative law judge is allowed by applicable law. Folks said this causes confusion, and about the ability to add issues beyond what was in the issues raised in protests. And we responded back to the group saying, it's funny that you mentioned that, because we've been looking at this rule and we're wondering whether it adds value at all beyond the model rules. And so it's been in kind of an internal debate as to whether it's actually a helpful rule on the whole. And so we asked you all to think about that. I don't know if you all have thoughts on that today. If you don't, that's okay. But we did note that we would bring that issue back. And Jesse, do you have anything else to add on this Division 75? Did I articulate that correctly?
Yeah, I mean, I think part of the reason that this wasn't touched in the draft was simply, it was another task to take on. And given that it was not, a 3544 or 3342 driven change, there are some complexities here because the hearing is not governed by 0005 include not only hydro, but also the department's enforcement proceedings, and issue identification in enforcement proceedings can sometimes be a little bit different. There's an intersection with the model rules that we have to be aware of. So because of the potential additional complexities surrounding that and just the large scale of the task that we're trying to accomplish here, this was left off the list for changes. So I think that, again, if there are thoughts on this, the department's open to them, but that is the reason why it wasn't touched.
Yeah, so I'd be curious to hear if folks, since we've got quite a few folks that are experienced, go through this process, if you all have thoughts about the value of this rule, or if you all don't, this may be something that gets addressed in the future. But it is one of those ones that we similarly had some discussion about, but in the interest of time and scope creep, we did not address. So thoughts on this one? Okay, I can tell that everyone just really wants to get to discovery in the hearing schedule, which, to be fair, is really why we're here. So if we don't hear any strong opinions on this one, we might not touch it. But I am curious.
Yeah, I'll just say that I think the comment you're alluding to was a comment Water Watch made, and I think our position is still the same, that that language is just confusing, and that we'd favor getting rid of it.
I think we may have gotten it from someone else too, on the rack. So so maybe we will discuss that particular component and at least leave the rule in place, not remove the whole rule, but we'll take a look at that as identified by the ALJ question. Anybody have other comments on that if we were to remove this part? Does that, raise any concerns, questions, cheers and support, I guess, at this point? We haven't, discussed whether that's a good idea yet, so I'm not saying we will, but I'm just curious if there's anybody else that has thoughts on that. Okay, not seeing any. I'm gonna get to what I think is what you all want to get to. So, which is 95. And that's discovery. So before, I'm sure you all are prepared for this, but before we go into this, I'm gonna see if I can make this a little bit bigger first. And I'll note that really where we had received initial concern on this rulemaking was around the request for admission, interrogatories, the limit on staff time for production of documents before it gets shifted to public records processes. There is also something about the subpoenas and also about the public record request and deadlines not being able to be extended at some point in time here. And then there was also just a lot of comments we received. Well, I don't know if there's a lot of comments, but we received at least a comment about the default hearing schedule and either why have one or just do the minimum required by the statute and don't address all of the different motions and things like that that could arise in a hearing. And so before we go there, I just want to provide a little context as to where the discovery piece under the model rules comes in. So it says, and Jesse, feel free to chime in on this, but I was looking at the model rules last night for discovery, and it's under 137.003.0566 subsection 2. And this is the provision that says that an agency may provide by rule that some or all discovery methods under this section do not apply to a specified program or category of cases. So, and then it continues on with an if, but that is essentially, I just wanted to note for folks, there is authority under the model rules for the agency to do this. Jesse, did I hit the nail on the head with that? And do you have anything to add about just where this kind of comes from?
Yeah, so the only thing that I'll add is that the rule calls out the methods of discovery. It is not the standard for discovery. So the rule changes that are proposed here do not affect the standard for discovery, which generally speaking is relevant evidence or, relevant documents or whatever request that you're trying to get at. Or things that are likely to lead to relevant information. So that is not affected by the rule. This is solely trying to get at the methods that the model rule lists and makes modifications to those methods.
So with that, I'd like us to start with, I think, subsection 1 here, which is the request for admission. And I'd like to open it up to see if folks have further comments on that, suggestions for what they think is reasonable. As a reminder, a lot of the background for this rulemaking and for the legislation is because the agency has a contested case backlog. And yes, I will use the term backlog because it's when you've had cases pending, in some cases for over 20 years, that is a backlog. And I think the goal here is to provide due process and a good hearing, while also part of doing that, though, is having timely decisions and timely hearings and cost-effective hearings. So we're trying to meet that goal by doing these things that the hearings process to date has not done. And I shouldn't just say the hearings process, it's our budget, it's many things that have not allowed that to occur. The quantity of cases, the time it takes to get through cases, the complexity, all of those things obviously contribute to this, the number of protests. And so we have limited resources and a big caseload. And so we do need to do something. What's occurring right now isn't working, and it's not because of our staff's good work. The limited staff we do have, it's not because of OAH, it's because there's just a volume there and the complexity, and we really do, and there's not enough staff to do it, right? Not enough money to do it. So as we've talked about with the rest of this work, is we do need to make sure we have an efficient process at the end of the day. So with that, I'd like to open it up and see if there's comments on the request for admissions issue. You can certainly start to comment on other parts of the rules as well, but I know discovery was the key area that you all wanted to talk more about. So comments here on requests for admission. Brian.
Yeah, so I mean, apologies in advance for I'm going to be talking a lot today probably, and sorry about that, but I have to live with this stuff, and I don't want to have to forever hold my peace because I didn't say something. But just first of all, just as an overview, I don't know why you're taking this on in the rulemaking. Certainly in the process of House Bill 3544, the issue was, how do we create some efficiencies? How do we reduce the backlog? And that was having to be balanced against how do we make sure people have adequate process to get the information they need to make their case. And House Bill 30, to the best of my recollection, did not direct any limitations on the methods of discovery or limit discovery itself. And I think that was a conscious choice and to not affect that part of the process. And so, taking that on now just seems to me really, really kind of inappropriate, and it's all in the direction of restricting the party's ability to get information in a contested case. And so our position is that we should just be scrapping this whole attempt to change discovery provisions for contested cases, and I really don't think that what's there in the model rules and so forth has proven to be a problem, at least in my experience, especially since we're going to talk about a default schedule that under the bill has to include discovery deadlines and 180-day time frame and so on and so forth. So that just, that's my, I guess, my overall comment on all this. And then just specifically with respect to requests for admission, I don't, I disagree. It's not an effective method of discovery. I think that used appropriately, it actually increases efficiencies by finding out what can be admitted and does not have to become subject to a bunch of additional discovery and so forth. I think, that's why you have a provision for that method in both the state and federal rules for court cases. And so, I disagree with the view that that's somehow bogging down the process.
So, Brian, I'm going to put you on the spot. Thank you for raising your hand and being willing to engage here. What do you think do you all have ideas about what could lead us to be able to get through these cases efficiently?
I do not think in my experience, discovery is not the problem. And that I don't think that the fact that there is an ability to use interrogatories or requests for admission, I have not seen that slowing down the process. I think frankly, I think that the fact is we have this direction in House Bill 3544 to have this default timeline of 180 days, and to set a default schedule for discovery requests and responses and motions to compel. I think just by virtue of the fact that discovery is going to have to be squeezed into those windows, it's going to do more than enough to make discovery efficient to the extent that people think it's not.
Do other folks have comments on that? So Brian, if I'm summarizing what I think I heard, I think I'm hearing that don't limit discovery, instead rely on the default schedule. And I guess the question I'd have for all of you attorneys / people that are involved in the contested case process, because I'm not, so I know where I don't know, is if we have this default schedule and there are a lot of provisions in the statute that allow that schedule to not be followed. Is the idea, Brian / anybody else, that because we have the default schedule, presumably there will be a desire to stick to that default schedule, and therefore discovery requests that require, I don't know, let's say a month of staff time, for example, would not be permissible because it just doesn't, it would have to be refined more. Is that kind of what you're saying, is because of the time limits, the amount of allowable discovery would be limited just by nature of the need? Is that what you're saying?
Well,
I guess.
I mean, I think people are gonna have to move more quickly with the default schedule on getting the discovery requests out and getting the responses out and filing motions to compel. I think, I just think that's going to have to move more quickly. As far as there's obviously a concern, which is also, being raised in some of these provisions about public records requests and the department being able to charge for responding to requests for production that it thinks are too extensive and so forth. But I guess I would just make sort of two general points. One, I don't think the existing discovery provisions are contributing to the backlog. That's not my impression from having been through a fair number of contested cases, including waiting around for stuff to get referred. Which honestly, I think that's where the big backlog is. But as far as this concern about the department getting discovery requests that take too much staff time to respond to, as you know, a party can object to a discovery request, including on grounds that it's unduly burdensome relative to the scope of the case and so forth. And to me, that is the process that ought to be used if the department thinks it's getting inappropriately burdened with requests for information.
I'd like to see Will or Jesse. Do you have any thoughts, since you all are closer to the process than I am on this, in terms of how much time it's taking, whether it's slowing the process down? I suspect motions in themselves take also time.
Yeah, I mean, I can just say that there are some cases where discovery is not a problem. Generally speaking, those are cases that are already where the requests are already roughly falling within the limits that have been proposed here. And then we have some others where that is not the case. And we have had instances, obviously the most dramatic has occurred in circuit court, but there's nothing that fundamentally different from, what's happening in circuit court is what can happen in an administrative hearing, where the department's, a substantial chunk of the department's entire legal budget was blown based on one set of discovery requests by one party in one case. And that kind of thing absolutely affects everyone else's due process and ability to obtain a hearing, because money is not limitless. And so trying to impose some kind of restrictions as to methods that kind of keep everyone within a playing field that balances the ability to obtain information with the ability to move forward and increase the volume of contested cases that the department can get through is the goal here. Part of the reason the department can't refer more cases than it does right now is because the department is estimating the amount of time and cost that it takes to get through each case that it does refer. And when we have outlier cases that, substantially exceed the limits that are being imposed here, that becomes a barrier to getting through the entire process more quickly. The department can and does frequently, object to informal discovery that results in motions to compel, and it responds to those motions to compel. That in and of itself is a time-consuming and costly procedure to have to go through. And, I think from the department's perspective, does not always result in, limitations on discovery that are consistent with being able to kind of move more cases at a more appropriate pace. So that, from where we sit on the department's end of things, and knowing the amount of time and effort that has gone into a number of the cases over the past few years in responding to discovery, that is a reason for trying to seek that balance.
I think, Jesse, thank you. And I think it's important to recognize that when we have a contested case, and so Will and Jesse, I'll ask you to help me flush this out, but it is often not just the money that we spend on our counsel and the money we also pay the Office of Administrative Hearings. So there's two places money is going, and money is billed by time on those ones, right? And then there is also the other pieces to that, which is Will's time, our protest coordinator, right? Wills can only do so much when he receives an extensive discovery request. That means he's not working on someone else's protests, right? When he's coordinating that with folks in the agency. There's then all of the other staff time. It looks like we've got Ryan Craybill in the waiting room. Laura, if we can admit him. And And so we also then have the subject matter experts, or the folks that are in the programs that are then often involved in the contested case process. And that can also, that means they're not doing, if it's, for example, if it's a groundwater application, that means the hydrogeologist isn't doing other work in the agency, right? If they're focused on that particular application. So there's just a lot of preparation, and there's many folks in the agency whose work gets tapped into when we do have a contested case process. And so I guess what we're trying to get at here is the more we spend on one, the less we're spending on others. And then that denies other folks due process, right? If they have to wait, 5, 10, 20 years to get a hearing on something. So, so with that, I guess this is a good conversation. This is helpful to hear Brian's perspective. I do want to open it up to, let's look at all of Division 95. I was thinking maybe we need to go one by one, but I'll open it up to the whole subject because Brian did just start touching on the whole subject there, and see what other thoughts and comments folks have. I guess there's a lot of silence in the room here, which is okay. But if folks have thoughts on this, either they like it or they don't, that would also be helpful to know. If you also have the key part for me at the end of the day is if you have ideas about how to make these processes provide timely decisions for folks, because in our mind, that is part of due process, is having a timely decision, right? So, Brian, since we kind of were going back and forth, do you have anything to add or anything to respond to on that front? And then I am going to see if there's other hands and other folks that want to comment.
Yeah, I guess just to point out that there are limits on discovery in the APA AG model rules. There's a limit to how many requests for admission you can serve, how many interrogatories you can serve, limits to what you can get document discovery on. I just don't think there's any basis to think that, those limits aren't appropriate to the processes around water, but they are for every other agency. And I don't want to lose sight of the fact that water resources is making a lot of important decisions here, and that to say like, oh, okay, we don't need as much information for the contested case process, I think would be misguided.
Thank you, Brian. And I'll also note that the model rules, while they do have those limits, they're also the source of authority for being able to limit the methods, right? And so there is, I think, an acknowledgement there that if there's certain findings made, which I'll point folks back to 566, that the model rules acknowledge that it may be appropriate. And I think that's what, the agency is looking at this lens through.
Yeah, I don't question the authority to do it, just the wisdom.
Yeah. Okay. Marika, I saw you had a hand. Oh, there you are. Hi.
Yeah, I'm here. But yeah, I figured I'd just offer some comments, especially since I did the first go round. And when we first spoke about this, I talked about our concerns writ large and specifically with this interrogatories piece. And I think, like Brian, don't have questions necessarily about the authority, but the kind of significant limits I think we see here, especially when compared to the model rules, feel like the discovery process is sort of serving as a little bit like the punching bag or the scapegoat for various issues that lead to the backlog. And I certainly understand that the discovery process is a piece of this. I know that Jesse has a ton of experience with that. But in terms of this specific piece, 5 versus a model rule of 20 is pretty low. And then there's also just not really any guidance as to how OWRD might give consent for more interrogatories. And so I think if, like what Jesse was saying, there's kind of these big outlier cases that are really the ones that take a lot of time and resources, we certainly don't want to punish folks who who don't fall into those outlier categories. And it would be helpful maybe just to have language around, how does the department decide if it's a case that's complex enough or requires kind of additional discovery, additional interrogatories? How might it make that decision to award those additional ones? I think that might be something helpful to think about. Said, I don't want to complicate the process too much, but that was one thing we talked through when trying to kind of meet the department halfway in these proposals.
Thank you. Thoughts, additional thoughts? Okay, I'm not seeing other hands on this. Anything else on 95? And maybe for the group, another question is if you think one of the levers on this rule is the quantity, right? So, a question I would have is, what do you all think is appropriate, right? Is there something that you think that is appropriate from a staff time level for every case? And do you think that there is a certain number of requests for admission or interrogatories that is lower than the model rules, but potentially higher, or dare I say less? I don't think less is what you all are looking for, though. But is there anything that is higher than what has been proposed in this draft, and or even on the hours of staff time for production, that you think is reasonable, that we would be able to say, this is we see the point, this is in the public interest, right, on the whole in general. And so I would ask folks that question as well, if you all think that there is a middle ground. I'm happy to hear any suggestions there as well. Okay. I'm not seeing any comments. We can come back to this if you all think on this more. Or feel free to submit, any thoughts via written comment for us as well. Let's go to the default hearings schedule because I'm not seeing any hands. Okay, so I'd like to solicit input on, this will make it so you can see it. There we go. On the, I just realized I'm not using the PDF version, so you all are getting all the different colors of different people that have edited this rule. So I apologize for that. All right. So I do want to see if folks have comments on this default schedule, and I'll open it to the group for that. I know there was some discussion, so some of the reason for the changes from the first draft to the second draft is we've had some discussions with the Office of Administrative Hearings. And they had some good points there for us to consider. So the schedule was updated. That's why it's all in yellow. For the purposes of this discussion today. As you all know, the law does require that we have a default schedule. I know there was some comments from the RAC originally around motions for, from some RAC members, not all RAC members, on motions for summary determination. And so I know that was an area that we heard a little bit on. Brian?
Yeah, I mean, I guess just to give you my take on the proposed schedule, I I guess to me the biggest problem with it, I just think the schedule for, well, I think the discovery request could come out sooner. Like as I understand what you're proposing, it would be within the requests themselves will be within 35 days of does it run from referral? Just is that right? Sorry,
Yeah, this would be from referral. So there's nothing that limits you from doing at least, initial digging, right? Before the
yeah.
yeah.
Yeah, and I think that could be, you could require that to happen sooner. And then I think there should be more time to respond to discovery requests, just as somebody who's been through this and had to do it. I think there should be 30 days to respond. And then I think there needs to be more time between the response and motions to compel. Because what you have to do before you know whether you need a motion to compel is you have to have time to review the discovery responses to see if you think there are things you should have gotten that you didn't. And sometimes that takes some time, especially if you're going through a big stack of documents. And sorry if I already said this, but I think there should be 30 days between the due date for discovery and a motion to compel. And let's see. Sorry, I'm just looking at my notes here. Yeah, so I think that'd be my main suggestion, and then I don't think you need a specific default deadline for responses to motions to compel, because there's a standard 7-day response time in the model rules, which seems fine. And I think if you started that discovery schedule, if you had the deadline for requests coming sooner, because I think what's going to happen is people are going to know if, as I understand, one of the reforms you're trying to make is to give people more advanced notice of a referral. So it seems to me they could have those discovery requests ready to go pretty quickly. That if you required those sooner, you'd have time to work in these periods I just suggested. So I mean, that's my main suggestion. The other comment I have is there's all this time and process devoted to a list of issues, which, like, everybody talks about how we need to make these things go faster, they need to be more efficient. I've always found that sort of process of coming up with an issues list to be a big time suck and really to be unnecessary. And it's not something that is done in the court process in either state or federal court. The complaint you file, which in this context is the equivalent of the protest or the request for party status, those should be sufficient to define the issues instead of going through a bunch of back and forth and motions and argument and everything else about how you summarize those issues that are raised in the protest. So to me that's just, like I say, if you want the process to be more efficient, take less time, I would cut that out. I don't know why that's done in these contested cases. Like I say, I think it's kind of a waste of time, but so those are my comments on the schedule.
Brian, you brought solutions. You must have heard me from the prior RAC meeting.
Sorry to shock you, Raquel, but every now and then, yeah.
So folks, for those of you that don't know, in a prior RAC meeting, I had noted, if you don't like what we're proposing, you know what we're trying to fix, bring me some solutions, because that's what the goal is, what's important, and the details, how we get there is open to the discussion. So Brian, thank you for bringing some ideas to the table here. I want to I see James has a hand. And then, so James, let's hear from you. And then I want to go to Jesse and or Will to see if they have, because like I've acknowledged, this is not my subject matter expertise. So I will call on Jesse and Will to see if they have any thoughts on what we just heard, as well as potentially from James.
Thanks, Raquel. James Fraser from Trout Unlimited. My question is just, what is the purpose of the new lead-in language that's highlighted about referrals submitted in compliance with the referral rule? When I read that, it seems to imply that there are referrals that would be submitted pursuant to other rules, or referrals that are submitted not in compliance with that rule, in which case the deadlines don't apply. Or maybe it means, an agency might initially attempt to refer a case but not meet all the requirements of the reference rule, and the purpose is stating that these deadlines don't apply. Okay, I see a thumbs up that these deadlines don't apply until it's fully and correctly referred, but
Correct.
just wanted to understand what that was. Okay.
Yeah, well, Donna has her hand up, so I'll give our partner an opportunity, but that was actually based on our conversations with OAH. That was a point that they had made to us, is that it needs to be a complete. We don't want to start the clock until it's actually accepted by them. Donna, do you want to expound on that? Thank you.
Super, and it's real simple, real quick. We do hearings for 65 different agencies. And sometimes when someone refers a case, they might do something like forget to give us the addresses of the parties. So it's required by 0515. Or gee, they submit it to the system and they forget to attach the actual notice that's at issue. So that rule lays out what has to be included in a referral. And what I didn't want to happen was to us lose time because we're trying to chase a document that should have been submitted to begin with. So it's not ominous, it's not referring to other rules, it's just saying, hey, the time starts ticking as soon as you actually get us what we have to have under the rule to start, which is the address of the parties, the pleading that's at issue, the request for hearing if it is, or the protest. I mean, it's different depending on the agency. But I'll give you an idea. Right now, I have a different agency that has a case sitting and I can't get them to respond, where we have a request for hearing, but we don't have the document that's the basis for the request for hearing. So real simple. And I don't know, Jesse, if you want to add anything on that, but that's why we asked that to have that added, because we just want the time to start once we actually have a referral.
Yeah, no, that's right. And I don't have anything to add. Yeah, thanks, Donna.
Thank you. That makes sense. Appreciate it.
Yep.
James, I can tell you're reading our documents. It's a very detailed question. So that's great. Jesse, did you want to go back to the comments we heard from Brian? Anything to note on that for us to think about?
Yeah, thanks. And yeah, I'd be interested in others' thoughts on this too. I am interested in that idea of moving discovery up earlier. I mean, first of all, for the benefit of the entire group here, not just the attorneys, the first step in discovery is referred to in the Office of Administrative Hearings process as informal discovery. So the idea is that the parties are trying to work things out amongst themselves before they file a motion to compel, if they think it's necessary to obtain discovery. There is no, there's no too early. in a sense, to be able to submit a discovery request. A party who gets an early discovery request may, respond back and say, I'm not prepared yet. But there's nothing that stops discovery from coming in early. The idea here was to set a deadline beyond which, you're too late here. You're supposed to have submitted your informal discovery request by, and here it's listed as day 35. I agree that if folks think that there is an opportunity here to move that earlier, that makes sense to me, because we have all these other events that start piling up, that some of which do, take time, and which we're needing to fit within this 180-day window. My initial reaction, Brian, was, okay, what do we do about if we're moving discovery requests earlier and that deadline earlier? What do we do if there's an ongoing dispute about the issues list? I do also tend to agree that, I think the goal here is to try to avoid issues list disputes in the future, in part by requiring parties to spell out in their protests what it is that they are intending to challenge. And so I think the hope is that, yes, this will be a less frequent occurrence. I don't think that there's a mechanism by which the department or anyone else can stop someone from filing a motion related to an issues list. The concept was to try to get that, to put a deadline out there for doing that. But at least I'm very open to the idea here of moving up that discovery request deadline, perhaps even to a point when, theoretically someone might have filed a motion pertaining to an issues list, just because at least the responding party will have the request there and be working on parts of the request that might not be subject to any issues list motion that does get filed. So in any event, this is, I think, something that has some promise from my point of view, and am interested, Brian, first of all, if you have any, other reactions, or if anyone else on the line has thoughts about these kind of initial steps in the schedule.
So folks, I just cleaned this rule up a little bit just because I couldn't tell what was going on with all the markups. So I hope that wasn't a distraction, but rather that it helps you all with your comments, because I found it distracting. So folks have comments or responses on this concept of moving discovery requests up?
So
Brian?
I have some reactions, but I want to make sure nobody else wants to talk first.
Yeah, I'm not seeing hands, which is why I called on you, because I could tell you were ready. So folks, you're all welcome to participate here. So feel free to raise your hand if you've got ideas or thoughts around this. Given that Brian does, I will go to Brian, and then we'll again.
Just a couple of quick reactions. Yeah, thanks, Jesse. So just to be clear that, my reason for suggesting we make discovery requests due sooner in the process was to try to allow more time for the responses and for review of responses and conferral, et cetera, before filing a motion to compel. So hopefully those things would go hand in hand. And then with respect to the issues list, and the possibility of a motion and over it and so on, I guess what I'm suggesting is that I think the issues list in its entirety is an unnecessary part of the process. I think that the issues should be defined by the protest, and it would just save a lot of time to not have to go through the process of coming up with an issues list and having motions over it and so on. Because at the end of the day, all it is an attempt to summarize what is in the protest. And I get that it is kind of nice to have, but it just seems to me, if we're trying to expedite things, that just dispensing with that piece of the process would be a good a good thing to do. And just like I say, there's no analogy in the litigation process. Everybody refers to the complaint.
Great. Thank you, Brian. I appreciate that.
Will.
Sorry about that. So I just that just raised a question for me, and that the new standards, the new protest standards do have some standards in there about, if whether an issue has been sufficiently raised, and, the need to provide information about how an issue is within the department's jurisdiction. And so it seems to me that they just provide those levers by which, potentially parties to hearings are going to, want to say perhaps like, well, yes, this issue is in the protest, but it's not within the department's jurisdiction, or this issue is in the protest, but it wasn't raised with sufficient specificity. And I guess this is kind of going back to sort of what Jesse said, in that it seems like there potentially are going to be disputes about issues. And so, I mean, I would love it if there weren't, and if there wasn't the need to develop an issue list, and maybe there's not. So I'm not, but it just seems like I've seen there be disputes, and it seems like there are with the new rules, there's the potential for disputes to, arise in the future. And so it seems like it might be wise to have some sort of sideboards on, when those disputes need to be resolved.
How much of this, Jesse and Will, can be addressed before referral, right? Because we will be getting the informally, I guess maybe that's not a thing, but I know kind of the goal in giving the initial, well, and now I can't remember because I know the legislation changed so much over time, so maybe this is no longer part of it. But I thought originally is part of the referral. Yeah, I think that got deleted. There was going to be the notice of when we were to give that initial notice, we were going to provide a list of issues. So I wonder if there's a way to speed it up by saying, and maybe we're just not that far in the process when we give that, initial pre-referral notice, right, of saying, here's what, the issues were that we saw raised in the protest. Do folks agree or not? But maybe that's not correct. So
I thought we actually, there is, maybe I'm misremembering. I thought we still had gone ahead and added something into
is it this one? Okay.
the rules about just what the department's goals are prior to
Oh,
referral.
here it is. Yeah, a proposed list of issues to be determined at hearing.
Yeah.
So we do have that in there. So I don't know, Brian, maybe to your point, maybe the process would go faster if we do have.
Yeah.
Or maybe that was your point. Maybe that was my point, Brian. Sorry, not to put words in your mouth.
Well, you didn't finish the sentence, but I think that was my point. The process would go faster without a bunch of back and forth on a formal issues list.
Yeah.
Yeah. So from my perspective, I think these are good suggestions and a good discussion. And so I think that Will and Raquel and I can sit down after this and think about some modifications and getting folks a revised draft out.
Yeah, just one other point in response to Will's point, just maybe think about, to the extent the protest raises issues, but you think they lack sufficient specificity to be considered, or that they're irrelevant or something like that. I think about whether that can be resolved on dispositive motions.
Other comments on this particular rule? Okay. So I think the next one, not seeing any hands. And again, if you have thoughts on anything we've discussed today, you are welcome to chime in at any and raise your hand here, and we can always go back to a point. So the next one I had just noted was these two rule divisions, I guess 220 and 225. Those ones are both, you know, lots of text and new, but I thought I would just check in. I don't know that there's anything really different or of concern there. These are so long, I can't show you all the whole screen. So I just thought I'd check in to see if there was anything in there that folks wanted to point out or discuss. And knowing that the RAC did not get to these quite yet, and we also haven't heard anything about this, you know, portion of the rules. I don't think there's much in here that's a surprise or out of, you know, I'm going to stop scrolling around because I can tell I'm just scrolling looking for someone to have a comment. So I'm going to pause there and see if folks have any comments on 225 or really any other component of the rules that you wanted to bring up today. Okay. All right, so I'm going to stop my screen share here and just look at everyone's faces. So final call, any other issues in any part of Division 2 that folks wanted to raise today, bring up? You're welcome to submit written comments. If you can't tell, we are looking at your feedback and we are evaluating it and making changes as possible. Okay. I see there's some things in the chat. Oh, those are all coming from Laura. Okay.
Yeah, just drop my email address in there for where you can send comments via email.
Okay. Are there any other comments? I don't think we have any other comments from anyone from the public that wanted to comment? Okay. Well, I think that wraps us up today. Jesse, was there anything else you had questions on for the RAC or any other comments you had related to this?
No, thank you.
Okay.
Yeah, nothing further from me. Thank you.
Donna is our fellow state agency. Do you have any other comments?
Nope, nothing from me.
Okay. And I'll note that OAH is here and they've been very clear, although we are state agency partners, they've been very clear about they are a neutral party. So I want to continue to make sure that everybody is aware of that because I know that's very important when I've had conversations with OAH. So we appreciate you all engaging as well in this process so we can make the best process. All right. Thank you all. I appreciate your time. And I think that is it for today. Please send us additional thoughts or comments and we will be working hard to take a look at them. And when we bring this back to the RAC, you all will see where we've landed on some of these issues. So thank you.
Thank you.